welcome to our second virtual First Fridays. It worked out so well last month that we decided we were going to do it again this month. So as people are joining, we're going to do a couple just introductory remarks. I think we're getting ready to go live on Facebook here in a minute. Well, it's been kind of a busy week, hasn't it, Lauren, this week?
It has.
Legislature and new cases being decided by the Court of Appeals in the past week or so. So we have a lot to talk about today, and it looks like we have a lot of questions too. So that's awesome. Well, I'm going to just start getting started here. I think we're almost live with Facebook Live. We should be in a minute. So welcome everybody to our virtual First Fridays. On behalf of myself, Beth Mulcahy, and Lauren Vie, from an attorney with our firm, we're so happy that you're joining us this morning. Just some starting points. I'm the managing partner and senior attorney for the Mulcahy Law Firm, and Lauren is an associate attorney with our firm. And we've enjoyed representing HOAs and condominiums for the past 24 years, plus 5 for Lauren, right? Or plus 6 almost, right?
Yeah.
And my firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. This is all we do. Our whole purpose and mission is helping community associations, planned communities, HOAs and condos with any legal questions that they have. And I can definitely say that one of the core values of our firm is education, providing education and having a place for owners, board members, managers to come and ask questions. So that's what we're doing here today. It's a free Q&A, and we're hoping to spend about an hour doing that. In addition to representing associations for many, many years, I also have served on and off of my board for many years, probably 14 plus years now. So I think I bring an interesting perspective as an attorney that represents associations, and then also as somebody who's served hard times, so to speak, representing as a board member in my community. So welcome to our firm's virtual First Friday free call-in. We had an overwhelmingly positive response to last month's virtual event. So we're hoping that this platform will continue to enable us to connect with you and answer a large volume of questions in 1 hour. And as you can see, Lauren Vie from our firm is joining me today to answer questions so we can get through as many questions as possible. During the first portion of First Fridays Live, I'm going to be discussing the new CDC Mask guidelines for vaccinated Americans and the executive order, common sense rules to navigate this unusual time, and then the pros and cons of conducting in-person or virtual board meetings and annual meetings, and how the vaccination of residents is going to impact your association. So let's get right into it. First, we got to announce our survey winner. Thank you so much to the 201 people who participated in our firm's survey. It really helps us get valuable information about how you're feeling about your associations, what type of education you want, are you ready to go back to in-person meetings or not? And so we're really happy that you participated. Can't believe we had 200 people. That's awesome. Now we got to do our little drum roll, because as we said in our, when we publicized it, anyone who submitted their response prior to this morning's live are eligible to win one of our $50 Amazon gift cards. And because we had such an overwhelming response, we decided to give away 3 Amazon gift cards. And we just did a random selection a moment ago using our computer system. And our 3 winners are Tony, who's a board of director from Corte Bella, Scott, who's a board of director from University Manor, and Louise, a board of director from North Commonwealth. So I don't believe I know any of you. So congratulations, you're going to be going hoopy on Amazon this weekend with your $50 gift card. My team's going to be contacting these folks via email today to let them know, and we will be sending you e-gift cards immediately. So thank you to the other people who provided valuable information to us. Amazing that we had 201 people helping us out, and a lot of the input that you're giving us will be put to great use in our planning for our virtual classes for the second half of 2021. One thing I want to mention, because I don't want to forget it, is it's Mother's Day this weekend. So for all the mothers who are listening in on this call today, happy Mother's Day. I'm looking forward to breakfast in bed and having a great weekend with my kids who are 14 and 13. So happy Mother's Day to everybody. Okay, next, let's talk a little bit about how we're going to use the survey results. So my team is going to be mining the survey results over the next few days, but I wanted to share with you some preliminary data regarding two of the questions we proposed in the survey, just to give you an idea of where people stand right now. So when we asked them, how do you feel about returning to in-person classes this year? 39% of the 201 people said, I think I'll feel comfortable with attending in-person class in October 2021. 26% responded with, I don't see myself returning to in-person classes this year. I'll see you virtually. 22% responded with, I'm 100% ready to attend in-person classes. And 13% said, I haven't made up my mind yet. So I think just kind of mining the data, we're really looking to see whether people are ready to get back to meeting in person and having classes virtually, and how they're liking the virtual classes, which we really are receiving a lot of positive feedback about. Just being able to log on in your PJs with a cup of coffee and have free education. The next question we asked was, does your board plan to meet in person for board meetings or an annual meeting during 2021? And 48% said yes. 31% said no. We're going to continue with virtual meetings until the end of 2021. And 21% said, I don't know. So great information for all of us as we're navigating these unusual pandemic, hopefully soon to be post-pandemic times. Okay, let's do a quick 411 on the CDC's new public health recommendations. So last week, the CDC unveiled a new mask guidance for vaccinated Americans, and fully vaccinated people no longer have to wear a mask outdoors, except in certain crowded settings and venues. So the CDC still, however, recommends that fully vaccinated people continue to take precautions in indoor public settings, like wearing well-fitted masks and avoiding indoor large-sized in-person gatherings. So here are the common questions that we're receiving right now in our office regarding, the pandemic and should we be meeting and how do we handle this new mask mandate? So the first one is, should associations enforce masks, owners or residents wearing masks outside on common areas? And so also ditto inside on common area buildings. So I think it's still a no-brainer that anybody who's entering the interior of a common area building still needs to wear a mask. The big question is that they're vaccinated and they're outside on the common areas. The CDC guidelines now say that unless there's a large public group there or large number of people meeting, that it's really not necessary. So I think we can rely on the CDC's guidance on this. What if someone refuses to wear a mask indoors in our common area buildings? I would just recommend that you remind them that it is still required to wear a mask. Hopefully it won't get to the point where you have to tell them that they have to leave if they're not wearing a mask. Can we meet in person now for board, committee, and annual meetings? So I guess that's the question of the day. A lot of boards are planning their meetings outdoors now, with social distancing. And that seems to be working well for others, but just do what's best for your community. If you're not comfortable yet to do that, you can still have the meetings virtually. In fact, almost all of the meetings that we're attending now are still virtual. So just know that you're not alone if you're feeling that way. Can we require residents to be vaccinated or show proof of vaccination? I've had this question a lot this week in my office. My opinion on this is no. I think that's just overboard. I think that there's some privacy issues here. So I would advise our clients and anyone who asks me to make it a requirement that you have like a vaccination passport in order to enter your pool or your common areas. I think that's just too much involvement and getting too much into the private lives of your residents. What if owners are having big parties on common areas with a lot of people? Should the association intervene? It depends on the number. So obviously, if somebody's having a party with 50 people, I think that you should be reminding them that the CDC guidelines do require people to be wearing masks. Can we continue with virtual meetings because we really prefer them? Of course you can. If that's the choice that your association wants to make and that's working for your association, you're definitely, able to do that going forward. Can we do hybrid going forward? Some in person, some virtual. I think that's probably what a majority of associations in Arizona are going to do now, because People are really liking the format, and it's working well for associations. Does the new law that Governor Ducey signed recently mean that HOAs and condos can't be sued or liable for getting or dying from COVID? Generally speaking, yes. It basically says that unless there's gross negligence on the part of the association, creating a danger for the residents, that the association, cannot be held liable. My team's going to be sharing the CDC's full article regarding the new mask mandates and new COVID, lifting of restrictions. So please take a look at that at your convenience. Okay, we've got a couple other things that are kind of exciting that are happening right now. I'm going to have you do the quick legislative update in a minute here, Lauren, just to kind of give you a little chance to talk. But this week we had a couple of federal rulings that were important. First, a federal judge ruled that the national moratorium on evictions that went into place last year to protect tenants is illegal. But now renters throughout the state of Arizona still remain protected by the Center for Disease Control's eviction moratorium. And that moratorium is set to expire on June 30th. We heard immediately that, this federal judge's ruling was, they've already filed paperwork to set it aside and appeal it. So we'll just have to see what happens. And we'll continue to monitor this situation. So now Lauren's just going to talk to you very briefly about 4 bills that our governor has signed and that will become law. Just so that you're aware of it, we are going to have a special seminar to talk through all these, really specifically, probably in June. But I'm going to switch it over to Lauren to tell you a little bit about what our governor has been signing into law.
Thank you. Hi, everybody. Good morning and happy Friday. So as you know, we watch the legislature throughout their entire session every year, and we keep track of laws as they're pending through both the Senate and the House and when they get to Governor Ducey's desk. So we have a couple laws this year. It's been a slow year legislatively for homeowners associations, but we do still have a couple that have made it through both houses and have been signed by the governor. One of them is SB1722, and this law makes it difficult and, in our opinion, nearly impossible for any kind of plaintiff to prevail in a lawsuit regarding the pandemic, so long as the association was acting in good faith. So if a homeowner, let's say, files a lawsuit claiming that they contracted COVID when they were in a common area, this law makes it difficult for that homeowner to prevail in the lawsuit, so long as it's demonstrated that the association was acting in good faith when they were maintaining that common area. Another law that Governor Ducey has signed is HB2770. This law basically states that notwithstanding any other law, a business in the state is not required to enforce a mask mandate on its premise if there's a rule that's established by a state, town, county, or any other jurisdiction in the state. Businesses can still decide to enforce a mask restriction. It just, they can't rely on a state mandate or a county mandate, whatever it is, to do so. He's also signed SB1722. So this bill basically extends the time that a political sign can be left up in a community up to 15 days after the general election, or if the sign is for a candidate who's in a primary election who does not advance the general election, it can be 15 days after the primary election. So basically, the law previously used to state that people could keep a sign up 3 days after election, and this law has extended the period of time for which political signs can remain in someone's lot or on their unit after a general election. So lastly, is HB 2170. This bill would be great for associations collection-wise. Basically, it states that it would allow the association to request any kinds of attorney's fees related to a garnishment, whether that's a garnishment of someone's wages, a bank account, rent. It allows the association to request any attorney's fees that were incurred in that garnishment effort and try to include those in the garnishment, which is very good for associations because right now, under case law in Arizona, we really can't do that. And it ends up resulting in the association having to waive some attorney's fees or not collect those from the homeowner. Lastly, our firm, we're still closely monitoring some more pending litigation. The legislature hasn't adjourned yet. They haven't adopted the budget yet this year. So we're still monitoring some bills that are moving along. One of them is HB 2030. And this bill would expand the list of flags that associations have to allow within the community to include first responder flags. It's probably not going to move any further, but because the legislature is still in session, this is still in play. Another bill is political activity in a community association. It's HB 2050, and the bill prevents an association from prohibiting or unreasonably restricting a unit owner's ability to peacefully assemble and use a private or common element if it's done in compliance with reasonable restrictions and for the use of the property that are adopted by the board. This bill probably also is dead, but again, because the legislature is still in session, we are still watching it because you never know. Sometimes things get passed through at the last second.
You can also find the legislative update that we do every week, updated with new information on our website at mulcahylawfirm.com. So please don't forget, we have our next class, our 5th class for the spring 2021 virtual HOA and Condo Academy on Tuesday, May 18th. We're going to be discussing how to work with your association's vendors in this class. And for more information about our upcoming classes, please visit our website at mulcahylawfirm.com. In the very near future, we're going to be announcing our classes that we're going to be teaching for the second half of 2021. And again, we're going to be using all that great feedback from you from the survey. So stay tuned for that. We'll be announcing our July through December virtual classes here very shortly, and probably some in-person classes too for the fourth quarter of 2021. Okay, so Lauren, I'm going to have you start out with the first few questions.
The first question, an association is having issues that's being overrun by short-term rentals, which in turn causes other issues such as noise, nuisance, trash, disruption after hours, and calls the police department. The association is looking for solutions to either eliminate or put a cap on the situation, and they're interested in any similar issues other communities are having and what their recourse has been. So short-term rentals are still a really enormous issue here in community associations across the country. It's just been something that we've been dealing with for several years. And in our experience, the very best way to deal with short-term rentals really is to amend your CC&Rs to impose a minimum rental period. I know that it can be very difficult to amend your CC&Rs. Every association has different percentages that they are required to meet in order to approve an amendment. But that really is the best way to go, because once something is approved by your membership, it's obviously been approved by over a majority of the members. It gets put into your declaration, which is recorded and runs with the land, and every owner is subject to it. So if you can impose or amend your CC&Rs to include a rental restriction, that really is the best way to do it. Please keep in mind that any kind of rental limitation that says, you can't rent a unit for less than 30 days absolutely has to be in your declaration. You cannot impose any kind of rule or policy that includes a rental restriction like that, because it won't be enforceable under state statute. Something else that you can do that can be really helpful is actually using your rules and regulations not to impose a minimum rental period, but to reinforce the use of the common area, any kind of noise restrictions that you have, please don't make noise after 10 p.m., making sure that people can't bring glass containers to the pool. All of those things can be really helpful. And something that I recommend is if people are struggling with short-term rentals, I suggest that what the association does, and our office can help you with this, is condense all of the rules that are really pertinent to renters and put them all on one page. Give them to the owners that rent their unit, and then tell them, please give this information to your tenant so they know the rules that apply to them when they're in our community. I can guarantee you the owner of that lot already gives that person a binder full of instructions when they come into their house. Almost every Airbnb and VRBO has them. So give them a little cheat sheet of the rules that apply to them. Also make sure that your owners who rent their units know that they ultimately are responsible for what happens when they have tenants in their unit. They're responsible for making sure that those tenants comply with the governing documents, and they're responsible for correcting any kind of violations that occur from that tenancy. So making sure that those owners understand that it's their obligation and responsibility can really go a long way in making sure that those owners ensure that their tenants act properly. If you have any kind of further questions on this, please feel free to contact us. This is a tough situation to deal with, and it's something that we can definitely help you with further. Okay, the next question. We are self-managed and it's getting harder to handle the workload on our own. I believe you. Self-managed is really, really hard. If there is enough money in the budget, can the board make a decision to hire a professional property management company without a vote of all the homeowners? The answer is probably, but definitely check your bylaws. Your bylaws usually have a section that lists all of the powers and duties of the board of directors. And 9 times out of 10, there is language that states that the board has the authority to hire a management company, vendors, attorneys, whoever else you need. So check your governing documents, probably most likely your bylaws, and see if you have that language. If you do, yes, the board can definitely make the decision on their own to hire a management company. But if it does include that language that you have to get membership approval, you will need to get membership approval. Okay. So how to handle violations of a rental property where the homeowner is doing nothing? That's a great question. So what you can do is really try everything that you can, phone calls, emails, letters, to get in touch with the owner. Again, the owner really needs to understand that they are the individual that is responsible for ensuring compliance with the declaration, and they need to make sure that their tenant is complying. Make sure that after reasonable notice and an opportunity to be heard, that you are imposing fines for any kind of violation. So the owner has kind of a monetary penalty and a monetary incentive to make the person comply with the governing documents. Check and see if your documents allow for self-help, if you can maybe clean up a lawn or something on your own and then charge the cost back to the owner. That has to be in your documents, so double check. And your last resort, if they really don't respond, is a lawsuit. That will most certainly get the owner's attention. It can be a harsh resort, but if they ignore you, it may be your only option. Okay, the next question. Can someone with no legal residency in the country serve on an HOA board? Yes, absolutely. I've never seen a restriction that says that somebody who's from outside of the country cannot serve on the board. We also have people who live outside the state serve on boards all the time. Okay, so the next question is, we are in the process of adding an impact fee for new homeowners. I'm assuming this is the same as like a transfer fee. It was stated in the letter to the homeowners that if a spouse, or family member inherits the home, that they would not have to pay the impact fee. I'm sorry. A homeowner who would like to downsize to a smaller unit in the community is wondering if the impact fee would affect the homeowner. This really depends on the way that your amendment is written. So for example, when we draft an amendment like this for a transfer fee, we do include language that says, like, if a property passes to a child via, probate or intestate succession, that they wouldn't have to pay the transfer fee. So you have to look at the language in the amendment that you're putting into your CC&Rs, because normally it has something to the effect that whenever title transfers to a different owner, that new owner pays that transfer fee or that impact fee. And I bet that if an owner sold a home and bought a new home in the same community, they would probably have to pay the transfer fee. So look at the language, and if you have a question, come back to us and we can help you. Okay, I am going to kick it over to Beth.
Okay, great. Next question. Our community is a 55 plus RV park with a maximum of 2 persons per unit, where residents own their land in addition to their park model. How does Senate Bill 1259 mobile home park caregivers affect our park? Does this mean that we have to allow caregivers over the age of 18 to live in with residents, which could mean 3 persons per unit? Since we don't represent mobile home parks or RV parks, it's hard for me to answer this question. But I can kind of switch it over and talk about how it would affect HOAs and condominiums. So under the Fair Housing Act, if somebody has a disability and they need to have a caregiver come into their property, an association, likely would have to relax their restrictions that they may have on occupancy or even age restrictions. So just keep that in mind. Next question. If our CC&Rs declare that it is the responsibility of the owners to maintain plants in or on their courtyards and patios, can the owners vote to approve an increase in the current budget to have our landscaper assume that responsibility without amending the CC&Rs? So great question, Steve. So you've got CC&Rs that say owners must maintain this area, but the owners now want to have, probably for efficiency purposes, right? They want to have just the landscaper maintain the areas in the courtyards and patios. So do we have to amend the CC&Rs? Well, I mean, best case scenario would be yes, because if the association's spending dollars to maintain an area that they are not really required to maintain, and somebody's not happy about that, what they, may have to do is reimburse the money in the future if there's ever a lawsuit. So I think it's best just to communicate really well with the owners, ask for their approval and a CC&R amendment. That's the safest thing to do. Of course, if you don't think anyone's going to challenge it, then you can go ahead and do it. But just know in the back of your mind that that could be something that could be challenged at some point. And if it's very clear in your CC&Rs that you're not supposed to be doing it, there could have to be a refund at some point to, for actually paying to have that done, if it could be determined how much that money would be for those special areas. Okay, next question. Are we required to have a handicapped parking space? We are a very small private community with no public area. So it really depends. Most of the time, cities, towns, counties, and municipalities dictate who needs to have a handicapped parking space in their community, and most communities do have one. So I would say check in with your city, town, or municipality to see what their requirements are. Next question. My board wants to approve the requirement for proof of vaccination to use our community center. I thought you previously said that this was not legal, yet I kept reading of this in many places doing this. What is the answer? And what is the legal explanation that I can take back to them? So, there isn't really a legal statutory answer on this. I wish that it was that easy. It's not, because this is such a new issue. Some associations are requiring this. I don't agree with that. It's my opinion that that is overreaching and that it could potentially be challenged down the road. Because remember that your CC&Rs are the contract between the owner and the association. And if the contract doesn't require vaccination, obviously it's not, right? Because the pandemic is kind of out of nowhere. And I haven't seen any amendments to CC&Rs that would require like a vaccination passport to use the common areas. These owners have a right to use the common areas, right? Of course, we have the right to pass rules, but we have to look at, are the rules reasonable? Wearing a mask, yes, that's reasonable in light of the fact that we're in a pandemic. Requiring somebody to potentially do something with their health that they may not feel comfortable with doing, I think that's overreaching. And even though I'm vaccinated and I'm not opposed to it, I still think that there are some issues that could come up, some personal rights issues. So we're advising our clients against doing this. And I'm, sure as I'm sitting here, I'm pretty sure that we're going to see some lawsuits on this. And I just don't want any of our clients to be one of those lawsuits, because those will be very expensive to defend. So the legal explanation is there is no guidance, but good common sense and business judgment tells me that it's not a good idea to make them do that because of the prohibitive cost if there is a lawsuit. Next question, A.R.S. 33-1242 and 33-1803. Where in these statutes does it say that the person accusing another person of a violation's name must be sent to the party they are accusing? One complaint form cites the above statutes. Of course, many people will not file a complaint because of this. Thanks, Beth or Lauren, whoever answers. Okay, so it is in there. That's just kind of a weird statute, though. So you need to know it. The statutes mirror each other in the Condo Act and the Planned Communities Act. And basically what it says is that, okay, the association sends a violation letter to an owner. And if the owner responds back in writing by certified mail to the association, there's certain categories of information that we're required to provide to the violating owner. And one of those categories of information is, what section in the CC&Rs have they violated? Another category of information that's listed in the section is who, witnessed or who saw the violation. And so 9 times out of 10, it's going to be the manager or the compliance person who's doing the drive-through in the association, but occasionally on things like dog barking or wild parties or noise issues or parking overnight, it's going to be a neighbor. And I think what we have to tell people is there's a possibility that this request will be made to determine who's complaining about them, about the violator, and your name will be disclosed. And that is just the way the law reads. So it is what it is. Next question. Thank you for the classes and help with legislative information so that we can be wise. My community is relatively small, 103 units. Who would we talk with at the legislature to get the legislature to reinstate the payment coupon books? It would save our owners and our association money. In addition, we are having difficulty with the post office delivering mail in a timely and efficient way. There are times that homeowners never receive their monthly statements. Thank you. Okay, so if you want to contact the legislature to lobby for new bills, basically figure out who your House and Senate representatives are in the state legislature. Start communicating with them by email. See if you maybe can set up a Zoom meeting to talk about these issues. Don't do it right now because the legislature's right on the 50-yard dash and they're trying to get the budget passed. I would do it either this summer or this fall before the legislature opens again in January of 2022, and ask your person who's your representative to introduce a bill. But you're going to have to be, the squeaky wheel. It won't happen unless you have a lot of people contacting them and unless you really push for them to do it. The other question is post office. Is you're having difficulty with them delivering mail? I recommend that your management company or a member of your board go down to the post office and talk with them and find out what's going on. We've seen this with other associations, especially newer associations in Arizona, where there's issues with the mail. And usually by going down there and talking to the manager of the post office branch that's closest to you, the issue can be resolved. Last question, then we're going to switch to Lauren. Our bylaws require an impound fee for all buyers of condo units, which is refunded on the sale of the unit. Since the board may use the funds for working capital per the bylaws, can the funds be commingled with the operating funds in the same checking account? If not, and the funds have to be segregated in a separate banking account, is there a minimum impound fund account balance requirement by law? Thank you. So quick answer to this would be, we never recommend that funds be commingled when you're doing either a transfer fee or a capital improvement fee, or in your case, the impound fee. I think it's best to be able to trace it in a separate bank account. But that's just best practices. Talk to your CPA, see what your CPA says about that. Is there a minimum impound fund account balance? You'll have to talk with your bank to see if there's any sort of a minimum, fund requirement. I'm going to switch it over to Lauren.
Okay, so our next question is, what are the typical legal expenses for a simple amendment to the CC&Rs, assuming that member approval is already obtained? So first and foremost, you should have your attorney look and verify that membership approval has actually been obtained. We need to make sure that the information that's on the ballot is valid and that you actually did receive the requisite approval according to your CC&Rs. Something else to consider is that once you have an amendment that receives the requisite approval, you actually have 30 days from the date of approval to record the amendment with the county recorder's office for it to remain valid. So you have a very tight timeline to turn that around. So if whoever asked this question, if you currently have an amendment that you believe received membership approval, you need to get to your attorney's office right away so they can verify the ballots and get something drafted for you so you can get it recorded with the recorder's office. So definitely get that checked out right away. And then that attorney will be able to give you an estimate as to how much it costs. It normally isn't a very expensive process. I'll say that. Once we can verify the ledgers, the ballots, we go through, we double check with the county to make sure that we have the appropriate information. Once we can verify that, we can basically draft the amendment document pretty quickly and record it with the recorder's office. The recorder's office has like a $30 recording fee, but get in touch with your attorney as soon as possible if you have approved an amendment, because again, you have that 30-day timeline that you have to work within. Okay, the next question. Our association is a small self-managed association with only 4 units. Our CC&Rs state that each owner is automatically a member of the board. 1 unit is owned by a trust, and therefore that board member does not live on site. If one of the owners has been given a notice of violation and requested an appeal, Do the other 3 members of the board have to be physically present in the same place to hear the appeal? Or can the one offsite member call in to listen to the appeal? And can the 3 members deciding the violation discuss it over the phone or email to come to a decision? So first and foremost, no. The board members do not all have to be in the same physical location. Obviously, because of the pandemic, we've all been meeting via Skype and Zoom and via the phone. So absolutely, you can hold a meeting where not every board member is physically present. In this case, any kind of an appeal of a violation would actually be discussed in executive session. I know you only have 4 members, but it would technically be closed to all the other members. So the board can, the remaining board members can, after the appeal has been given, they can discuss the appeal and the violation privately, but they cannot do that via email. That would be a violation of the open meeting law. So you need to discuss it over the phone or via Zoom, or if you want to meet in person, great, go ahead. But you should discuss and make a decision regarding the appeal via a properly noticed executive session and not via email. Okay, so the next question, our HOA has published rules for replacement of windows to match the exterior color. One owner obtained approval for replacement windows in accordance with the rule and then installed a different color and is now asking for approval of the new color. What are the implications for the board if they ignore the published rule and potentially approve a waiver of the rule or basically the new windows as an exception, with the expectation that the rule will change later in the year to bring the non-compliant windows into compliance? If owners have expressed their objections to this change, how can this be done? So that's a good question. So what I would say is, one, homeowners, when they receive approval from the board or an architectural committee to install or replace something in a certain way, the owner is obligated to comply with the plans that were approved by the architectural committee. So this owner is definitely currently in violation of your policy, not only because they install, their windows don't match your policy, but because they didn't apply or install the windows the way that it was approved by the board or the architectural committee. So that is a violation. If the board is experiencing a situation where you think you may change this policy down the road, I wouldn't wait until a year later. I would bump this up as quickly as humanly possible so that this property remains out of compliance for as little time as possible. Don't wait a year, because then you have this question of somebody's not in compliance with the rules and then the board isn't enforcing the rules. You want to make sure that you're enforcing the rules fairly and equitably for all of the homeowners. So bump that process up, try to change the rules as quickly as possible. Don't wait a year, because that's how you get into trouble and you can have to deal with an accusation from another homeowner stating that you're not applying the rules fairly to everybody else. Okay, so the next question, can the homeowners association restrict the sale of a home to only one rental property? Our office is not fans of rules that limit the number of homes that can be rented. We prefer a minimum rental time period. So, everybody can rent, but they can't rent for less than 30 days or 60 days or a year, or whatever you want to make it. That's what we prefer. Could the association theoretically do this? Yes. If you amend your CC&Rs, it just can be difficult to track, and it probably wouldn't pass. You would have an owner that would say, wait a second, we don't want only one, the ability to only have one unit rented at a time. So I would say maybe look into including a minimum time restriction instead of only allowing 1 or 2 homes to be rented at any given time. Okay, the next question, are meetings of the officers of the association, who are also board members, subject to the open meeting law if they want to discuss bringing a proposal or request or action for the board? This is a good question. So it's rare that you have a meeting of simply officers. If you are a member of the board of directors and you're meeting together and a quorum of you are together, it's a meeting of the board of directors, and it should be properly noticed under the open meeting law. So if you're considering maybe having or drafting a proposal that you want to submit to the rest of the board, the way to meet without triggering the open meeting law is to have less than a quorum of the board meet. So if you have 5 board members, have 2 of them meet, work on the proposal, and then you can present the proposal at an open board meeting. Okay, so Here's our next question. Our CC&Rs stipulate that buyers of properties in our community may not rent out that property until the new owner has occupied the property for 1 year. What we are seeing in the properties that are being bought, that they're being bought by persons for their parents to live in. So technically the situation violates our rule about the owner living in the property for 1 year. Should the parent/occupant be considered a renter? The CC&Rs are meant to discourage rental properties, but this situation doesn't seem to fit that restriction. Is there some way to look at this that will allow the purchase of our homes for one's parents? So I think that depends on how you look at this. I do not consider a situation in which a individual purchases a home for their parents to live in as a rental. Just because someone is living in the home who isn't the person who purchased the home, that doesn't mean that the home is being rented. If the parents are paying rent to the child to live in the home, then yes, I think you could consider that a rental and it would be subject to your 1 year limitation. However, if these are just people who are buying homes and then allowing their parents to live in them, that's not a rental. There's no exchange of money. And so that 1 year limitation really doesn't apply to them. So I don't think you would need to amend your CC&Rs to allow this situation to happen. I think it already can happen. Okay, I am gonna kick it over to Beth.
Okay, great. Next question. Our community allows certain units that have too short of a driveway permission to use a visitor parking space to park per our living rules. We recently had a rental unit that has permitted that use store an extra vehicle in the visitor parking for 1 month and not move or notify our management company that they were parking their vehicle there. Management company called the police to determine if it was stolen or abandoned in order to have it towed. It was neither, and the owner admitted he has too many vehicles. Since a towing provision isn't in our CC&Rs, how do we handle this situation and get the tenant into compliance with our rules? The owner has once again parked the extra vehicle in our visitor parking as he states he's working on the issue. He's also threatened to call the police on the HOA. Okay, well, that's going nowhere. Calling the police on the HOA, I can tell you right now, don't worry about that. As long as you're being reasonable and professional in how you're dealing with them. So how do we deal with an owner who is overreaching on a perk possibly that the association gives to certain owners who have a driveway that's too short to even park a car? They're going overboard and, parking there. I guess maybe what you should start by doing is look at the living rules, see if they're clear enough that, it's clear that if somebody can't park in their driveway, how long they're able to park in the visitor parking and how many vehicles they're allowed to park in visitor parking. I think that would be one suggestion, really tighten up those living rules. Second, you may want to consider amending your CC&Rs to give you the authority to tow for anybody who violates in those situations. Also, you may want to fine that owner for the ongoing violations. So parking is a big issue. We know that. We deal with a lot of parking issues in addition to a lot of short-term rentals, as we've heard a lot of questions on short-term rentals here today too. So I think those are some good suggestions to point you in the right direction. And our office is always here to help you. Sometimes it's great when you have a violation for the attorney to reach out to the owner and let them know how serious it is. It's escalated now to the attorney, and we may need to take legal action if these issues aren't resolved. Next question, we are assessing our residents for our streets, and a resident posted on Facebook for our residents that she knows how this works and someone gets a kickback because she knows what's going on. Also, we have been accused of fraud and impropriety with this issue. How can we put a stop to this type of slander on the board? I will say that when you serve on your board, it is the most frustrating time of your life. I truthfully can say that. When I was on my board, I think it was probably when I was the president of my board, it was the most unhappy year of my life, without a doubt. So just know you're not alone. I think what I would say is the best way to counter negative feelings like this on behalf of a homeowner is to communicate the correct information, encourage people to come to board meetings. Have newsletters, a website that contains accurate information. And frankly, in this situation, I would have your attorney write this resident a letter stating that she's defaming the board, she's defaming members of the board, and that person needs to cease and desist. If this has gained any traction or steam and you're hearing that there's like a removal petition going, you may want to have a town hall meeting to address this issue. You may also want to put out a letter to the community, maybe even from your attorney, saying that these allegations are false. Next question. Do vendors' contracts discussed and approved in an executive session by the board also need to be approved in a general open meeting? So yes, actually contracts should be discussed and approved in the open meeting. The only time that you can talk about a contract in an executive session is if you're doing like a review of the contract, like a performance review. This particular association said, we are voting on a change of attorney for the association, but the management doesn't want it brought up in the general open session and feels the only important vote is the executive session. That is wrong, and that should be done in the open session. The word budget does not occur in our association's CC&Rs, and the word budget only appears twice in our bylaws, where it talks about that the treasurer should, with the assistance of the board, prepare and present to the members at the annual meeting a budget for the fiscal year. Secondly, it says we should prepare and present to the members at the annual meeting a budget and a projection of long-term fixed asset reserve fund expenditures. Nothing in this section mentions the need for a vote or approval of the budget. Traditionally, the budget with line items has only been on the annual meeting ballot, along with the election of board members, an increase in monthly assessments, and any other issues that need approval, which require a majority vote in favor of the individual items. With nothing in the CC&Rs and the bylaws requiring the approval of the budget, must we continue the tradition of requesting member approval of the budget? So I don't know if you're, it doesn't look like you're a condominium based upon the name of the association that you put in the question. So my feeling on this is if it's not in your documents that you have to have membership approval of the budget, you don't have to do that because you're a planned community. Maybe you've done it in the past. It kind of doesn't make sense because the board members are the ones that are most familiar with the numbers. And so they should be the ones that are voting on whether or not the budget is, approved for the next year. Again, though, you may be required to get approval if there's an increase in assessments that is, something that would be outlined in your documents. So if you're going above a certain percentage, that may be a separate issue that you have to vote on at the annual meeting. How much should an HOA have in its reserve funds? You should be having a reserve study done by a company that does reserve studies, and they can tell you how much money you should have in there based upon your community's amenities and common areas. We are seeking an arbitration settlement for attorney's fees with the homeowner over an occupancy issue. If we prevail and the homeowner refuses to pay us, can we lien their property for the attorney's fees, that are regarding this occupancy issue? So likely no. The only time that you can lien a property for unpaid attorney's fees is for the collection of unpaid assessments. Last question, then I'm going to flip it over to Lauren. After the annual election has taken place with the election of 5 board members, is it legal to add 2 more board members after the election has taken place? I mean, it's unusual. I have actually a couple issues like this right now that we're dealing with in our office. So, usually the reason why you add board members is because you have too few, you need to spread out the workload. But sometimes, and that's an okay reason, right? I'm fine with that. But sometimes people add board members because they're scared of losing the majority or they want to control. That's the wrong reason. And trust me, that's going to backfire for you if your board's doing that. So I would look at what your documents say. Do the documents allow the board to expand the board? If so, then follow what the documents say. Sometimes, the board can appoint additional board members for the additional spots that they create. Sometimes it has to be thrown back to the members to elect them. But that's kind of a controversial issue. So get some advice from your attorney before you do that.
Okay. So our next question, can we add a ban on rentals of 30-day or less? And if so, does it apply to current owners, even though they are already doing short-term rentals? Yes, you can absolutely, amend your CC&Rs to prohibit any rentals under 30 days. And yes, it would absolutely apply to all of the current owners. They would be the ones voting for it. So if they vote for it, then they should understand that they are limiting their right to vote. You can potentially include what's called a grandfather clause if you have owners that are pushing back. That actually will allow the current owners to continue renting for less than 30 days, but once title transfers to a new owner, the new owner is subject to the 30-day minimum. That's a great way to get a rental restriction passed so that in the future you do have a rental restriction in place, but you can actually feasibly get it passed because it doesn't affect the current owners. Okay, so our next question, they're looking for the proper way to assign fines. Our rules provide that fines for trash cans and parking for parking violations. After the initial notice, what is the appropriate way to assess fines for subsequent violations? And then this individual lists their fine policy that includes, parking receives a fine for $50 for the first occurrence, $100 for the second, $250 for the third and fourth. That is a fine way to assess fines. Basically, what you want to do is you want to give somebody notice of the violation. You want to let them know what provision of your governing documents they're violating. And you want to tell them, hey, you need to correct this. Here's the timeline that you have to correct it. And if you don't correct it by this deadline, we will impose fines. So make sure your fine schedule, looks like you already have one, is available to the members so they have notice of what they will be fined. You can also put that in the letter and say, this is, you'll be fined $50 if you don't correct this violation in 2 weeks. That's absolutely fine. But you do want to make sure that people have notice of the violation, an opportunity to be heard regarding the violation, because sometimes they disagree with whether or not their action is actually a violation. We also do recommend kind of a courtesy notice. Some people don't realize that they're in violation of the CC&Rs, so sometimes a friendly notice actually gets the issue taken care of right away. If they don't take care of it, the schedule that you have here is totally fine. As long as fines are reasonable and you notify homeowners that, hey, this fine will be imposed, that's the best way to do it. When you send subsequent violation letters, make sure that you tell the owner again in each letter, if you don't correct it by this date, there will be a fine imposed, and tell them the fine that will be imposed. Okay. So next question, our association is working on updating our CC&Rs, and we have a few issues that the board is not in agreement with on changing. The issues involve pets, cumulative voting, rentals. They want to poll the owners to get an idea of what their preferences are in these issues and then go to the majority on the issues. As this is not a regular vote, how do you suggest we do this? Okay, so you can do this a couple of different ways. SurveyMonkey is totally fine. You can send out a postcard to the members asking them to mail it back to you. You can hold a town hall and get their opinions and see what they say. That's absolutely fine too. Just remember, you're not holding a member vote. You're not, amending the CC&Rs. You're just getting their feedback. So email, mail, in person, that's all fine. Okay, our next question. We have an architectural change request form in our rules and regulations, which is to let the board know of any interior changes, such as electrical, plumbing, and major renovations to each condominium unit to be submitted prior to making the change. The purpose is to ensure that the owners of the other units are protected and hopefully using a licensed, insured, and bonded contractor, as well as protecting neighboring units. The process is not always followed, and some owners state that the board has no authority to require this form. Can we create a rule or regulation to replace this form, which holds the owners fiscally responsible for any damage to their neighbor's unit or a building caused by their changes? So first and foremost, you probably want to check your governing documents, because since you are a condominium, generally, anytime a homeowner wants to make any kind of structural change to the interior of their unit, they do generally need the approval of the homeowners association, because it could affect common elements. So it could affect electrical or plumbing or something that affects another unit. And it's important for the board or the architectural committee to review those changes. So look through your CC&Rs or have your legal counsel look through your CC&Rs. This may be something that's just already required, and these homeowners are mistaken in saying that the association has no business asking for this form. If it turns out that their change is something that only applies to their unit, maybe it's electrical that only affects their unit or something like that, then yeah, maybe they don't need the form and maybe the association doesn't need to know about that information. But to answer your question, so you could create a rule that, I mean, technically the owners probably already are financially responsible if they cause damage to another person's unit or to a common area. I can bet you that you do have language in your document that states that if an owner damages a common element, that they're responsible for remitting payment to the association for the repairs. So double check the language in your document, because you probably already have information like this and wouldn't need to create a rule or any kind of regulation. Okay, next question. When we amend a document like our rules and regulations, are we required to mail a copy out to the homeowners, or is emailing or posting to our bulletin boards okay? Probably yes. So double check your governing documents. I know you're sick of us saying that, but double check, because you probably can just make this available to the members. At a kiosk, you can email it, you can post it on your gate or something like that. Double check to make sure, but you definitely do want to make sure that homeowners are aware that you've created a change in the rules, because obviously they can't really be held responsible for a rule that they're not aware of. If you do want to post it somewhere, maybe also send out an email saying, hey, we've posted our new rules and regulations in the bulletin board. Make sure you check it out and make sure that you can make copies available for them if they want it. Okay. So the next question, is the HOA liable if someone falls into a plant and suffers an injury, such as a cactus or a shrubbery that has sap and is caustic to your skin or eyes? I'm assuming that due diligence would require such plants being removed, and that the association is a condominium community, so the HOA board oversees landscaping. So that depends, I guess, on whether or not there was any kind of bad action on the association's part if they didn't maintain a common area. So something that we've seen before is if there's maybe a crack in the sidewalk that's, not level and someone trips and they say you didn't properly maintain the common area because this, uneven surface created a tripping hazard, then yes, maybe the association could be held responsible. And maybe it depends on the placement of these cactuses or these plants. But if they're in a planter area, we live in Arizona, there are cactuses. They're just kind of unavoidable. I don't think the association can be held responsible for simply having a cactus in an association in Arizona. But it may depend on the placement of the cactuses. So you may want to take this to your landscaper to see if they think it's safe, or maybe your association attorney, and see if they have any comments for you on this. Okay, I'm going to kick it over to Beth.
Okay, great. So the next question deals with sewer damage that occurs where, let's say that there's a sewer pipe that enters from the common area street onto an HOA's property. And how do we determine who's responsible for the damage if the sewer pipe, separates, or it gets, has tree roots that get into it? We've had this issue quite a bit in our office. And actually, I think maybe somebody that we may have written an opinion for recently is asking a question on this. So the key thing to look at when you're trying to determine who's responsible for repairing a broken sewer pipe is the language of the CC&Rs. And, many times these cases are kind of hard to determine who's responsible for what, especially when there's interior damage due to the sewer pipe. So what I would recommend is, so how do we look at these issues when there's a separation of the sewer pipe or it collapses due to age? We really look carefully at what the CC&Rs state. And sometimes it is kind of a gray area, no question about it. But typically when there's a gray area, you just have to look at the plain meaning of the language in the CC&Rs. And that's what we do in all these cases as we're giving opinions, who's responsible for what. We go to the CC&Rs, we look at the language, we try to make the best possible decision to limit the association's liability and to make sure that we're being fair in our analysis of the situation. Okay, next question. Can a community with governing documents that are silent on short-term rentals incorporate into their rules and regulations certain restrictions for short-term renters, such as maximum number of individuals in the renting party, minimum age, no parties? Really, all of those restrictions are use restrictions, and they shouldn't be in the rules. They need to be in the CC&Rs where all the other use restrictions are. So we would not recommend you putting those type of restrictions into the rules. Next question. An owner is requesting that the HOA pay for replacement of her damaged patio fence. She was informed by the board that the patio fences are the responsibility of the homeowners and the board will not pay to replace her fence. She's now disputing the board's decision. We want your opinion regarding the decision. The following articles from our CC&Rs appear relevant to the board's decision. The first section is the description of the term unit. This includes the patios and the fences are on the patio property and not the common area, except each such unit shall include as an appurtenance thereto the exclusive right to use and occupy the parking and patio areas bearing the same number as the unit as shown on the plan. Let's see, not all units have patios or fences. Some homeowners have already replaced their fences at their own expense. Our monthly assessment and reserve fund does not take into account the repair or replacement of patio fences on individual units. Okay, so it's hard for me. I don't have the full section of the CC&R, so it's kind of hard for me to look at this, but based upon the section that you're giving me, how the term unit is defined, it includes the patios and the fences. Let's see, you're saying that they're on the patio property and not on the common area. So, I mean, everything that you're saying to me here leads me to believe that the board made the correct decision. Sometimes, you know, especially it looks like in your association, there's different units that are situated differently. Some have the fences, some don't. And that's common, you know, because the configuration of condominiums and townhomes is often, it's not the same because it's spread out over a lot of property. But it looks to me like the decision that you made was correct as the board. Okay, our next question, our CC&Rs and architectural rules have a section regarding motor vehicle parking that states that in no event shall overnight on-street parking be allowed on any street. According to A.R.S. 33-1818, you know, there's a section in there that talks about if the association HOAs have no authority over regulating public streets, including parking, for planned communities where the declarant or CC&Rs are recorded after 12/31/14. I understand communities with the declaration recorded before 12/31/2014 may continue to regulate as the CC&R state. However, I found some interpretations that say if the HOA has publicly owned streets and amends their CC&Rs for any reason after 12/31/14, they can no longer regulate public streets according to the original CC&Rs. Is that interpretation correct? So this is 100% a gray area. I haven't seen any case law that addresses this. So what we've got is we have a statute that was adopted by our legislature, signed into law by our governor, that is unclear basically on this issue. And I think the intent of the statute was that for any associations that have public streets after 12/31/14, any new associations where, you know, the declarant is creating the association, records the CC&Rs after 12/31/14, that the association shouldn't be able to regulate parking on those public streets. But there's some question as to, okay, well, what if we amend our CC&Rs? Does that apply? Does that mean that our association can't regulate on street parking anymore? You know, it's a gray area. I don't know what a judge is going to say on that. I think just looking at it objectively, I don't think that they will say that the on-street parking is no longer going to be able to be regulated by the association if you amend your CC&Rs after 12/31/14 and you were created before that date. But I don't know what a judge is going to say, but that's, my opinion at this point. Okay, next question. When a board member resigns, should the association notify all members of the opening prior to filling the seat? Or should all have an equal opportunity to be considered? Or can they fill it without any notice? I mean, it just depends. I mean, either works, truly. You know your association best. If you know it is like impossible to find board members, and somebody, you got a live body with the pulse who's saying, hey, I'll do it, you might want to secure them in the position quickly and appoint them. If you have 15 people who want to run for the board, and they're just clawing their way to get on it, then there's going to be public scrutiny if you just appoint somebody without putting the names out there. So, either works. Just do what's best for your association based upon, the facts and circumstances in your association. Next question. Besides e-statements, Please talk about ways to save money on sending billing statements per Senate Bill 1531. Our property manager told the board that they could switch from monthly billing to bi-monthly billing and cut the costs of mailing billing statements in half. But the property management could still allow residents to pay monthly, making it mostly transparent to residents. Is this acceptable and legal? You know, I have to see what your documents state. If your CC&Rs state that, you know, you have to have, you pay assessments monthly or that there's monthly, dues, then you really can't do this workaround that the manager is talking about. If it just says there's an annual assessment and the board is, determining that, they're dividing it up over 12 months, it's possible that that could work. So I would say talk with your attorney definitely before you make a final decision on that. And I'm going to flip it over to Lauren now.
Okay, so our next question. Is it okay for about 2 out of 3 administrators on a community Facebook page to be 1, board members? So board members have a majority of the administrative role, and to make that group a restricted Facebook group for just homeowners in the community, whether they are trying to use the HOA records to validate or just by asking them a question. So basically, yes, there really isn't any kind of law that governs, these Facebook groups or administrators. So yes, they can be board members who run the association Facebook page, and they can make it a restricted group that basically only applies to homeowners within your community. And they can try to verify by looking through records and seeing, okay, is this person actually a homeowner? That's absolutely fine to do. If you want a different policy in place, you may want to speak to the board and say, hey, I think we need a written policy regarding the Facebook page, and see what they say. Okay, next question. Can you please give us guidance about pool rules this summer? I would say business as usual. You know your community best. If you think more restrictions are needed, that's fine. But right now, it seems like it's business as usual based on the orders from our governor and the recent direction from the CDC. Okay, can a board redistribute funds with a dedicated reserve line item for another unplanned reserve expense if the original funded reserve item is deemed unnecessary by the board? An example is a dedicated line item for the street seal coat. The board determines the streets do not require a seal coat at this time and would rather reallocate those funds to a much needed landscaping project. They can, so long as they're allowed to do so by the governing documents. It's rare, but I have seen some governing documents that include language stating that, a reserve fund is only going to be used for specific purposes. So definitely double check your governing documents, but the board probably can go through and kind of change that line item as they see fit. They should, if the board does have a reserve study, you may want to also consult the reserve study and make sure that the board is making an educated decision as to reallocating funds that may, be dedicated for an item that may become necessary in the next year or so. Okay. The next question, all of our owners are seniors. Our HOA, consisting of 14 units, is exploring dedicating our community as a 55 and older community. Are there legal requirements to create such a community, and what is the process? Yes, there are legal requirements. You will need to comply with the requirements that are imposed by the Housing for Older Persons, or HOPA. Some of those are making sure that, a certain percentage of your units are occupied by at least one person who's 55 or older, that you take a survey every couple of years that verifies that your community is meeting the percentage that you dictate. I suggest that you reach out to legal counsel to get this process started for you, because you do absolutely want to make sure that you are complying with the requirements for the federal law to actually be established as a 55 and older community. So reach out to your legal counsel as soon as possible. Okay, next question. If a board member disagrees with other members of the board about an association issue that impacts said board member personally and financially, can the board member take the issue to small claims court while still remaining on the board if they so wish? Or does this conflict mean the board member must resign even if they don't want to resign? We don't suggest that anybody resign for this situation. Every board member has the right to resign if they want to, but you can't force somebody to resign. They can only be removed by the membership. And keep in mind too, that a disagreement doesn't necessarily mean that there's a conflict of interest. It just means that you have different opinions and you are only two people on a board of however many other people. So you could still bring a legal action and remain on the board, but it will make for a very unpleasant time on the board of directors. And just remember that technically when you are suing the association for a decision that's made, you are kind of technically suing yourself if you're a member of the board of directors, because then you have to defend the lawsuit. Okay, so our next question, do directors need to use video at a meeting? Our board refuses to do so. No, they don't have to use video if they don't want to. Next question, what should we be doing to protect our reserve fund from theft? So something you can do is have all of the board members be signers on the account for a reserve fund. And we actually have a really fantastic cheat on embezzlement and fraud that you'll want to review, because we have a lot of advice on how to protect all of your assets and all of your funds from embezzlement. Okay, we have units of 4 and 5 under one roof. Most termites are found in the garage. If an owner won't let us drill and treat the garage, we are likely to have termite damage and won't have a warranty on the home. Can we require them to let us drill and treat the garage area? So this depends on, I guess, who's responsible for the garage area, to be honest with you. If the association could be responsible for that area, yes, you can force them to do that. I also would suggest seriously talking to the homeowner and saying, hey, we're trying to take care of this for you so this doesn't spread. Please give us permission to go into this area and treat this matter. You can also remind the homeowner that if they are aware of an issue like this, I mean, termites can obviously cause serious damage. You want to let them know, if we don't treat this now, and we are offering to treat this for you, you will be responsible for the damage that they cause. And, you want to make sure that you put that in writing so that if they do deny it, that you can go back to that writing later on and say, we did warn you about this. You knew about this damage. You ignored it. And now you've caused damage to other units. So I guess long story short, I would need to review your governing documents to see who is truly responsible for that garage area and what authority you as the board do have to correct issues like that. So contact us or your legal counsel so that we can give you a straight answer on it, but you definitely want to get in touch with that owner to make sure that they understand the seriousness of the situation. Okay, so next question is, can an association amend their CC&Rs to limit liability by requiring written notice to the HOA to cure the matter in dispute? And can you amend to say, in addition to any rights already existing under Arizona law, the HOA shall be entitled to reasonable attorney's fees and costs if it prevails in any legal action brought against it by any lot owner? I thought that we could not do this, as you said that we cannot get our fees in an action at the OAH, which is the Office of Administrative Hearings. But one of our board member wants to amend the documents to include this. That's a great question. So there are a couple different issues to deal with there. So you could put something in your CC&Rs that, state that the association is not liable for these things, or that the association, if there's a legal action, that, if the association is deemed the prevailing party, that the association recovers its legal fees. That is absolutely fine. That usually applies in a situation in which there's like a breach of contract claim or something like that. When you reference the OHA, the Office of Administrative Hearings, that is a special situation because state law does not allow any party to ask for their attorney's fees in an OHA or an ADRE hearing. So that's why that specific situation is a little bit different. If somebody were to file a lawsuit, let's say against the association in Superior Court or Justice Court, that's a situation where the association could potentially ask for their attorney's fees back if they're deemed the prevailing party. And that's when we would refer to that language in your document that says, look, the owner signed a contract. The contract states that if we're the prevailing party, we get our attorney's fees, and that could be very helpful. So yes, you can do it. The OHA is just a special circumstance in which state law does not allow any party to collect their attorney's fees in that matter. Okay, how do we manage if our HOA hasn't held any meetings since December of 2019 and they won't work with us to use Zoom? I am sorry to say that this means that the association is in violation of state law. Both the Condominium Act and the Planned Community Act require the associations to hold an annual member meeting every year. So you do have to hold meetings once a year. I suggest either submitting something in writing to your board, telling them that this law is in place, they have to hold an annual meeting, or you can also circulate a petition in the community and try to call that meeting with a certain percentage of the homeowners to kind of force the board's hand to hold a meeting.
All right. The homeowners are deceased and the home is now for sale as a HUD home. The assessments on the property are not being paid, and I do not know who to contact. We've never had this situation in our HOA. Also, the home is not in compliance when the owner was president. Yikes. And nothing has been done to bring it into compliance in all these years. The other owners are upset about this, are wanting to know when the home is going to be sold. Will the board be able to enforce the CC&Rs? When a HUD house is sold, do we get the same form to sign off the house? Okay. There are special rules for HUD houses. There are always problems. I do not understand why, but they always refuse to pay assessments and they frequently let the property go into disrepair. So you should just know that you're not alone. I've seen this before with other associations too. So a couple thoughts on this to help. Number one, you should lien the property for the unpaid assessments right away, because that's the only way that you can ensure that you will be paid on the unpaid assessments. If they owe more than, the statutory requirement to potentially foreclose on the property, you should really consider foreclosing, because that may be the only thing that you can get HUD's attention with. On the condition of the property, I got to tell you, it's not good news, because you can do self-help if your documents allow you to, and then you can go in and clean it up and try to charge HUD for it, but they will refuse to pay for it. So what I usually tell clients in this situation is, it's unlikely they're going to do anything on this. So either you pay to have self-help, and hope that they'll pay it at the close of escrow when the lien's being rectified, or you may have to eat it. It just depends on what your threshold is for, how bad it looks. So, there typically is a disclosure statement that's done when there's a HUD home sale. So you should, get paid on that, on your lien. If it slips through without a title company contacting you for a disclosure statement, you can go back to the title company and to HUD and get it paid. Okay, next question. What can we do about a new owner that has an old renter constantly harassing our board members? He tells other residents lies about the board. He yells personal information. He has a prior arrest history, says slanderous things. We've had to call the police on this individual for threatening one of the board members. So new owner who used to rent there, so he's got some history apparently. And I think we just treat this person just like we would any other difficult owner, right? I think that we get the attorney involved for the association. We send the owner a letter notifying the owner that the behavior is inappropriate. If it escalates to the point that we need to get an injunction preventing harassment, we can go to justice court, and any individual member of the board or the manager can get a specific injunction against this person if there's been, threats of harm or actual physical harm. Reach out to your legal counsel to discuss this. We're equipped to handle these problems. This is what we're here for. So, possibly the attorney writes a letter, maybe we intervene, continue to call the police if there are additional incidents, because that's a really important paper trail. Next question. What if the declarations belong to a larger organization and we, a smaller HOA within that org, can't make changes to them? So we've got the typical master sub situation, and you're in the sub, the master documents can't be changed, by your association. I mean, I hate to say this, but you are kind of stuck with it. So what I would suggest is get on the master board, try to make change from within on the master board, but don't bang your head against a concrete wall, just trying to make change from the sub association board. Next question. If the community manager inspects every 14 days, board members walk specific streets daily, AM and PM taking pictures of home violations or just walking by for exercise, yet they look at our homes. Community manager says they are allowed to do this anytime along with any homeowner. What are your thoughts? This is just like a balancing act between overzealous and normal, right? And so it's hard for me to say, because I don't know if a homeowner is asking this question or if a board member is asking the question, but I mean, let's just be reasonable, right? A board member who is, sneaking around at night looking for violations, okay, that's not cool. That's not working, right? But if a board member happens to see something when they're walking by and it's something that is a violation, I mean, I'm on my board right now and I see things that are broken, or sometimes I'll see a violation and I'll snap a picture of it, just send it to the manager, hey, check this out. That's fine. So you just have to have a good balancing act on this would be my comment. We only have about 5 more questions or 6 more questions. Our HOA has 42 resolutions written over 20 years. How do we condense them to make them simpler for all residents to know and understand? Well, it sounds to me like it might be time for you guys to do a document amendment, because 42 resolutions is a lot of resolutions. So you may want to think about how you can incorporate those into your rules or your CC&Rs. Would be one suggestion, or you could create like a book of resolutions, which would be kind of unusual. I think I'd really have you rather go the document amendment route. Is there any issues that are required by law that need to be discussed in executive session? A good question. So the executive session statute says that the board has the right to go into executive session. It's not an obligation. So really the board chooses whether they go into executive sessions or not. I mean, my recommendation as legal counsel is anytime you're talking about legal advice from an attorney, ask the attorney if they think it's a good idea to go into executive sessions, because probably 100% of the time I'm going to say yes. So short answer, you're not required by law, but it's recommended to go into executive session under the categories that state law allows you to go into executive session for. Next question, what can be done about rogue board members? A really good thing that we've been doing recently is we've been conducting boot camps for board members, where either Lauren or myself goes into the board meeting and we do an education seminar and we talk about what are the problems, what things are going well, what are some blind spots we have here, what's everybody's personality types, how can we all work better together? So I think that would be a good suggestion. Another suggestion would be to maybe adopt a code of conduct. We have a great cheat sheet on that on our website at mulcahylawfirm.com. That might get some of the rogue behavior under control if everybody sees what the expectations are for the board members and follows them. How do we get our HOA management company to respond or do anything? Well, I don't know. It looks like maybe you might be a homeowner. So, my feeling is you're, as a homeowner, you are, of course, a member of the association, but ultimately the board is dictating, how the manager is responding and doing things and living up to the contracts. You may want to run for the board and get more involved to, hold that person more accountable. If the HOA pays the water bill because there's only 1 meter for the whole property, if a resident keeps watering the grass outside his residence, even after he's been asked not to several times, can we do a special assessment against him? For the amount the water bills go up. Our water bills doubled last year because he watered so much, which it went up more than what the HOA brings in per month. Okay, so what you may want to do in this situation, short answer, no, you can't do that because it's too hard to prove. You could consider submetering, although there is an expense to do that. We have seen some associations submeter the lots. You can put like a water lock on people's properties so that they don't do this. I think those are some good suggestions. The last question is, does the architectural committee need to be a separate committee? And are we allowed to know who they are? So it just depends on what your documents say. Some boards operate as the architectural committee. Some architectural committees are appointed by the board separately. And they're not all of them are board members, but remember, under Arizona law, a board member has to chair the architectural committee. Are we allowed to know who they are? You bet you are. So certainly they should be providing that information to you. Okay, some closing remarks. Thank you so much for joining Lauren and I today for our second virtual First Fridays. Thanks for being here. Thank you for caring about your community. We responded to 60 questions in about an hour and 10 minutes because I think we had about 20 minutes of introductory remarks. So thank you so much, everybody, for being here. We got through a lot of questions today, covered a lot of territory. Again, we hope that you will consider joining us for our next First Fridays, which will of course be the first Friday in June. And then don't forget that we have our next virtual seminar coming up here in about 2 weeks. So be sure to think about attending that. We're going to be talking again about how to work with your association's vendors. And that will be on Tuesday, May 18th at 11 a.m. So thanks everybody for being here with us today. Don't forget, we've got a ton of great resources on our website at mulcahylawfirm.com. And we're really active on social media. As soon as the legislature closes this year, we're going to be letting you know and getting out our final legislative summary. And we just appreciate you being here today. So on behalf of Lauren and I and our entire team, thank you, Morgan and Yvonne, for making this happen behind the scenes. Happy Mother's Day, everybody. Have a great week and weekend, and we look forward to seeing you again soon.